designation or a beneficiary designation to name the university for that one account. Everything else I have is going to go to my kids. In fact, I just did that for a client last week. Now, why do you do that? Well, one of the reasons why you do that is that's going to be a charitable deduction, so that will apply as a deduction against estate tax. But also, that way it goes directly. There's not going to go to court. It's not going to be battled over. Everybody knows it's intended to go to that charity, and it's just done nice and clean. Or similar, perhaps I have money that I want to go to my grandchildren and everything else to go to my kids. So maybe I'll set up a separate account for each grandchild and name that grandchild as the beneficiary on that one particular account. Maybe I want them to use it for college or something like that. So these can be used both to avoid probate, not having to go to court, but also for kind of targeted and strategic distributions without having to go through probate directly from the financial institution to the person or the charity. A lot of people don't understand that. They think, okay, the will says this, but these beneficiary designations will override the will in that respect. All right, let's talk about joint tenancy because I forgot to talk about this. Okay, here's an acronym that you'll run into quite frequently. I apologize for my bad handwriting. So we're talking about how to avoid probate here. Let me just back up. When I talk about avoiding probate, again, I'm talking about not having to go to court after someone dies. One way to avoid probate is to have an asset that's owned by more than one person with survivorship. Let me write that on here. Okay, survivorship. Survivorship means that more than one person owns the asset. So let's say a bank account, checking account, a joint checking account. So my wife and I, we have a joint checking account. We can both write checks on it. If I die, she's the co-owner. It's all hers automatically. That avoids probate. Now, I could add a child, a lot of people will do this, onto the account as a joint owner. Joint tenancy with right of survivorship. That's what JTWROS stands for. You'll see that oftentimes on bank statements or brokerage statements or whatever. Joint tenancy with right of survivorship. That means that you have more than one person that is a co-owner of that asset. That could be a car, a boat, an aircraft, a bank account, a brokerage account. In real estate, we have it, it's called by a different name, but basically it's where you have more than one owner, and there's survivorship, so that when one person dies, the survivor owns it. So now how do you use that for estate planning? Why would you do that? Back to the bank account. So let's say my wife passes away, so now I'm the only owner on my checking account. I'm getting older, perhaps I'm having some memory issues, so maybe I'm going to add one of my children onto the account, or maybe all of them, as a joint owner with survivorship. That means if I die, it goes to whoever I added onto the account automatically, don't have to go through court. That's great. They can also sign checks while I'm alive, so if I need help paying my bills, they can do online banking, they can access all the account statements, they can do all of that, because they're a co-owner. Downside, we talked about this already, right? They can go drain that account, because they own the money equally to me. Even though it's my money, because they're a joint owner, they can pull every last dollar out. So you got to be careful about that. When you set up a bank account, you may not want to add somebody on there as a joint owner because you may not trust them, 100%. The other problem with adding them as a joint owner while you're alive is if they get into a car wreck and they get sued, or if they get divorced. I had this case recently, well, not a decade ago. That's recent to me. So I had the parents that added their son onto their joint checking account for that very reason, to be able to sign checks and stuff. Of course, the son ended up getting divorced, and their checking account got drawn into the divorce case. Now, we made it clear to the judge that they added the son for convenience purposes to avoid probate, and it wasn't intended to be a joint marital thing. So eventually they got it back, but we had to go to court and argue over that. It was a pretty good sized account. Yeah?
So if they were to have done a prenuptial agreement, that wouldn't have came into effect, right?
Okay, so the question is, if they would have done a prenuptial agreement, that would not have happened. Partly true, yes. Partly not true, and the reason why I say that is, the judge can still, the judge will look at, in a divorce case, all assets available to the spouses. And then the judge will make a determination which assets are joint marital and which assets are not marital. So it still gets sucked into the case. Now, then the judge will have to determine, okay, if it's an individually held asset, such as an inheritance, has it been commingled, and should it be kept out of the divorce division? So there's kind of a two-step process there. Number one, what are the assets? Number two, are they considered joint between the spouses? So the judge will end up looking at it, because the person's on the account, they are a co-owner. But then the judge is going to say, all right, well, this really wasn't intended to be a marital asset. It was intended to be a convenience for the parents. And therefore, the judge would exclude it. But the judge doesn't have to. Now, here's where you get into problems with that. If the child puts their own money into that account on a consistent basis, they commingle or they use the money from that account for their own things, or they use that money to remodel the house that they own with their spouse. I've seen that happen. Now the judge is going to say, well, it's not just a convenience for the parents. This really is something that's been used for the benefit of the marriage. And now you got a problem. So the other thing too is, like I say, if they get into a car wreck or they don't pay their taxes, and now there's a lien, they can go seize that account. So there's kind of a good side and a downside to it. The other alternative, just so you know, if you don't want to add a child onto your account now, as an owner, you can fill out that form I was talking about that gives them signing authority with the bank, so they can sign checks. But that's only while you're alive. That goes away as soon as you die. And then the payable on death form that you filled out would take over from there. Another thing about this joint tenancy that can be a problem. And I'll give you a real world example. I had this case a few years back where the dad had a joint account. Well, it's his individual account. He added his son to the account as a joint owner with survivorship. So he could write checks and do that kind of thing. The dad then had a farm, who sold the farm. He put all the money from the farm sale into that account. Several $1 million. He'd already filled out a payable on death form for that account, naming his 3 children, including the son that he added to the account. So dad dies. So as the joint owner, all of that money, the bank messed up. You don't really have a POD with the joint. So the dad wanted that money to be split 3 ways. But because it was a joint account, it went 100% to the son. Now the son didn't want to share it with his siblings. So we ended up in a lawsuit over that. We ended up settling the case, but it got really ugly. They all hate each other now. Clearly it was the dad's intent that he wanted it to be divided 3 ways, just the bank didn't do the forms correctly. And so from a technical legal standpoint, the money was 100% the surviving son's money. Because it was a joint account.
He was the only one, not the other.
Correct, he was the only one on there. So that's their problem. You know, there's advantages and disadvantages. The advantage to it is you can sign checks and help the parents out, but the disadvantage is, and it really wasn't so much the son, it was the son's spouse, the in-law, that wanted that money. That happens a lot.
Selfish people.
Yeah, yeah, frankly, yeah, they were being selfish. We settled that, they each ended up getting a third, but it completely ruined the family.
Yeah.
I mean, they don't talk to each other now.
Yeah,
It's really kind of sad.
Yeah.
It really is. All because of that one form. So at any rate, so there's advantages and disadvantages to that. One of the big advantages of the joint tenancy route is it's much quicker because you're already on the account. But that can also be a disadvantage. All right, a couple other ways to avoid probate. I'm going to come back to trusts. Small estate. Let's talk about that real quick. Okay. Small estate. So we have, when we talk about going to probate, that is after somebody dies, we have two types of procedures. We have what's called a full probate, which is all of the multitude of different papers that have to be filed, accountings and inventories and notices and publication in the newspaper, and it's a big drawn out process. However, if you have a estate that is not high in dollar value, you can file a one-time filing with the court, which is called a small estate proceeding. It's actually called a small estate affidavit. An affidavit is a sworn statement. And this is true if you have a will or if you don't have a will, either way. And basically, this is limited, in Oregon at least, $200,000 maximum real estate value. Doesn't matter if there's a loan or not. You go by the total value of the real estate. And or $75,000 of non-real estate assets, so cars, bank accounts, whatever. If the asset base is below that, you don't have to do a full probate. You can do a small estate, which is a one-time filing. It's much less expensive. It's pretty straightforward. They actually have a form online that you can do yourself. So it's pretty straightforward and easy to do for the most part. It's not perfect, but it works pretty well. Question?
Now there's not really much real estate that is
Right.
under
No, that's not indexed.
Okay.
There's a lot of discussion about that. Yeah. When they wrote that, and they came up with that dollar value, it was about 15, 20 years ago, I think.
In the last 4 years, it's almost doubled.
Very hard to find real estate, even in Eastern Oregon.
Yeah.
I was looking at LeGrand real estate the other day, and even there, even out Elgin. So,
Anywhere.
yeah, pretty much anywhere. So, yeah, this is becoming less relevant. But where this really is useful, even still today, it's not so much for real estate. It's for like a bank account that only had one person's name on it. Maybe dad's name was on it. He didn't have his wife on it. Have that happen a lot. And, maybe it's got $10,000 in the bank account. So it's not a huge account, but it still has enough value to justify filing. So you can file that, and then the bank will transfer it over.
For other.
Yeah, or a car.
Or,
Yeah, now the DMV does have a process right here, my next one down. Department of Motor Vehicles affidavit. An affidavit is a sworn statement. So Department of Motor Vehicles, if the only asset you have is a car that needs to be transferred, then all of the heirs can sign off on it and then tell the DMV where it's supposed to go, which is great. You don't have to go to court to do that. But the downside to that is, what if the heirs don't get along? So let's say you have a car and all three of them want the car. And they can't agree on who's going to get it, so you can't really go through that process because all of them have to agree. So then you'd have to go to the small estate process. So, or I've got one right now where the only asset is an old beat up pickup truck that for some reason This was, again, a second marriage. And the husband and the wife bought this old beat-up pickup truck for their farm. And their names are on the title, but they don't have survivorship. And let me talk about that point. This survivorship thing also applies to motor vehicles. So normally, you know, when a married couple buys a vehicle, both their names will be on the title. That's a form you fill out at the dealer. And there's a little box you got to check that says survivorship, yes, no. And a lot of dealers don't have any clue about this.
I would
no
know.
clue.
Yeah.
And so they didn't check it, so there was no survivorship, even though they're married, between them. So husband owns half, wife owns half. So he dies, now under his will, everything goes to her. But now we got a probate to get one half. I mean, I don't think the thing is worth maybe $2,000. But she loves this truck and, you know, pulls her horse wagon with it. It's probably worth more than that, but you know, maybe $5,000. So yeah, you could try to do this process, but guess who's going to have to sign off? She will, but also his children. They hate each other. So now she's going to have to file with the court just for this one truck, because they didn't check that little box on the title application.
So if they did, it would go to.
Would have gone straight to her. She would take the.
Yeah.
So the way that that works, just so you know, is you take a death certificate to DMV, and then they remove the dead person's name from the title. Yeah. Same thing with a bank account. Same thing with all these. You give them a death certificate, they remove the deceased person. The survivor becomes the account owner. You use the social security number of the survivor to now report on taxes. And it's a real simple process. All right.
Sad but simple.
Yeah. Okay, gifting. Gifting right now, as an estate planning technique. Now one, you know, you gift for birthdays and holidays and whatnot. That's not what I'm talking about. What I'm talking about is gifting for estate planning purposes. So the way it works under current tax law, you can give $15,000 per person per year, and there's no tax implications whatsoever. You don't have to report it. It's not income to the person who got it. You can't deduct it, but you don't have to report it. It's just, here you go, here's up to $15,000. Now this is total. That includes birthday presents and holiday gifts and just cash money, whatever. Now why do I put this here under, you know, from an estate planning standpoint? Well, let me show you. So let's say, and I've had this situation come up many times. Let's say we have grandma, and you know, she's mentally competent. Actually, I had cases where she wasn't, but they had a power of attorney that allowed for this. So grandma, let's say, is worth $1.1 million. She is declining in health. She's getting older. So if she dies right now, that's $100,000. That would be subject to Oregon estate tax. So that's going to be $10,000 in tax. $1 million tax-free. Anything above $1 million subject to Oregon estate tax. So $100,000 over, $10,000 in tax. All right, so we got this $100,000 here. So she has 4 children, and they are all married. So what she does is she gives each of them $15,000. That's 60. And then she gives each spouse $15,000, which is another 60, so that's 120. And now when she dies, she's only worth $980,000. Literally, this is done in 10 minutes. Write a bunch of checks. So now she dies, she's worth $980,000, below the $1 million threshold in Oregon. Doesn't even have to file an estate tax return now, because she's below the $1 million. So you just saved 10 grand in tax in 5 minutes by gifting that money out to your children and their spouses or grandkids or whoever you want to give it to. So I know that sounds kind of goofy as an estate planning method. Perfectly fine. This is done quite frequently. Or maybe, you know, you're worth 1.7 million. And so you do this every year. You give a little bit away every year. So you draw that down, you're giving it to the next generation, and that way they're not going to have to pay tax on it. Now, there's a downside to that, of course. What if you need the money, right? This is assuming you've got the cash to be able to give and you don't need it. So it's not as quite as simple as I'm making it sound. Now, in her case, she did have the money was all basically in cash. So that is where we use gifting sometimes. Now, this can also apply, although it gets really technical and this can draw audits very quickly. So what if instead of giving cash, you have a company and you give stock in that company worth $15,000 to your children every year? That way they're becoming part owners of the company, and then when you're reducing down your estate over the course of years. The problem is, how do you determine what percentage of the company is worth $15,000? So you have to have it appraised every time you do it, and that's expensive. It's also a headache if you could even get that. Go ahead.
So this is to avoid being taxed, right?
Right.
So do you get taxed on that stock? If you...
Okay, so when you receive the $15,000, you don't pay tax.
Yeah.
And grandma doesn't have to pay tax on it either. It's just, here's a gift.
Yeah.
That's the maximum amount you can give per year without any tax implications
It's
whatsoever.
only when you die, then there's a tax, or?
No. Because see, what happened was she was worth $1.1 million. So if she would have died then, 100,000 of that 1.1, so 1,100,000. So 100,000 is the amount above the $1 million exemption. So then she's going to owe, they'll owe tax on that 100,000, which is 10%. So that would be 10 grand in tax.
Gotcha. Okay.
So if she gives that money away, so now she's below $1 million when she dies, no tax.
Gotcha.
So that is a common method. Now again, this could be done with anybody, children, doesn't have to be a family member, you can give to anybody. Obviously it's a charity, it's totally different because that's deductible anyway. But this can get very complex. When you're talking, people that are in the millions and millions and millions of dollars, there are whole gifting plans that can be put together to help minimize that and also to transfer that ownership interest. Maybe it's a farm or another kind of business. Okay, and then finally we have what's called a life estate. Again, we're talking about how to avoid probate. These are not real common. I don't really recommend them, but these are kind of old school. They used to do this all the time. Saw this a lot in the Midwest with farm property. So a life estate basically is when you transfer your ownership to real estate to perhaps your children. So you give it to them, but you hold back a life estate, which basically means you continue to be able to use and live on the property while you're alive, but when you die, your children are what are called the reversionary owners. So you transfer the property to them, but you reserve a life estate. So that basically means you are still the owner while you're alive, but then when you die, the kids own it, no probate. Used to be really common. We don't really use them too much anymore because there's a lot of problems with life estates. But you do see those occasionally. And one of the problems of the life estate is, what if you need to sell it to pay for your health care? You don't own it anymore. You can't sell it, among other problems. So but I just want you to be aware of it because they do occur. You see them happen. All right, so let's move on and talk about trusts. So trusts are becoming, well, they have been a very important planning tool for years. And first of all, I just want to talk about kind of the basics of what is a trust. So first of all, there are different kinds of trusts, but they are all based on the same idea. And that is, a trust is a separate legal entity. And what I mean by that is, it's kind of like a corporation is a separate legal entity. A nonprofit organization is a legal entity. A government is an entity, a legal entity. A church, a school, any kind of an entity type thing. It doesn't really, it's not really alive. It's a piece of paper, a paper person. So the way that a trust works is basically, because it's a separate legal entity, when you set up a trust, it has the legal authority to own assets, just like a corporation does. So you set up a trust, and it literally, piece of paper. I could set up a trust here in 30 seconds. I, John Hasbrook, hereby establish the John Hasbrook Trust, dated May 11th, 2022. I will be the trustee of my trust during my lifetime. However, if I become incompetent or upon my death, my wife, Michelle Hasbrook, will become the new trustee. Upon my death, all trust assets will be distributed to my wife. If she has predeceased me, all trust assets will be distributed to my children equally, or their share will go to their children if they should also predecease me. Date, signed, notarized. One page. Now, most trusts are much longer than that. But essentially, what you're doing when you set up a trust is you're creating a separate entity. So it works like this. So we have a trust, and we have the person who sets up the trust, which is sometimes, they're referred to as the trustor, sometimes called the settlor. They will then transfer assets to the trust. Now, what do I mean by that? House, you deed your house out of your name as a human to your name as the trustee of your trust. So now you don't own your house anymore. The trust owns it. Your bank account, put it into the trust. Your car, your gold, all of your personal possessions, farm implements, equipment, sporting goods, everything you own, other than retirement accounts for the moment, it all goes into the trust. So you don't own it. The trust owns it. Now the person in charge of the trust is called the trustee. The trustee, while you're alive, usually will be yourself. If it's a married couple, they set up a joint trust where they put their joint assets all into the trust. And then both of them will be the trustees. When one of them dies, or if they become incompetent, the survivor becomes the sole trustee. When they both die, then you name an alternative trustee, which is called a successor trustee. And I like to have at least 3 alternatives. So like for me, my wife and I have a trust. 2 of us are our trustees. We put our house, other assets into the trust. And then when we both die, it's going to go to our children. My oldest will take over as the new trustee. And then the trust itself, that piece of paper that you did, which created the trust, will tell the trustee after you die how to divide up the assets. Now the trust, again, because it's a separate legal entity, it doesn't die. When you die, you don't own anything because your trust owns it. So there's no need for probate, that is, you don't need to go to court because the trust owns the asset, not you. and then the trust language will dictate where that money goes, that kind of thing. Now with that said, I said retirement accounts. I typically will not put a retirement account. Well, you can't, a trust cannot own a retirement account for the most part. There are a few exceptions, but sometimes we'll name a trust as the beneficiary. So if I have a retirement account, and when I die, that money from the retirement account will now go to the trust and then be held if it's a underage kid, like we talked about. So we can name the trust as a beneficiary. The long story short, the advantage of a trust is, number one, it avoids probate. And this whole idea is the trust owns the asset rather than you. Number two, a trust allows for all kinds of complicated and intricate planning like we've talked about. You know, if I die and I'm over $1 million, then anything above $1 million will go to my surviving spouse, and my $1 million will stay in a separate trust so you can divide it up. Or if I die and any child, in the determination of my trustee, maybe it's my brother, that has drug or gambling or other kind of problem, then my brother would have the ultimate authority to decide not to give him the money in their own and absolute discretion. Or the trust could say, if I have a disabled child, then their money will be held in that trust forever, because perhaps they're not disabled when I write the trust, but then they get into a car wreck, and maybe they have brain damage or something. We don't want them getting that money, but I did, you know, that was after I wrote the trust. So trusts can be used and have all these contingencies built into it. The other advantage is a trust is essentially private. It doesn't have to be part of the public record. Now there are different kinds of trusts, which I'm not going to get into all of them here. But essentially, most trusts are going to be called a revocable trust, meaning during your lifetime you can change it, modify, amend it, terminate it, do whatever you want. There are trusts that once you set them up, you cannot change. That's called an irrevocable or non-revocable trust. They're very rare. It's very rare that people should do those. We really only use those for certain things like Medicaid planning or life insurance to pay estate taxes like I talked about earlier. You got to be very careful, because I've seen scams on the internet where they want you to set up an irrevocable trust, and the whole idea is you'll never be subject to federal tax again, and because you don't own anything and all this kind of internet stuff. Don't do that. You can. It's a scam. A lot of those are scams. All your money's gone. You just gave it away to somebody. So, got to be very careful. For the most part, when you set up a trust, you want it to be revocable, modifiable, and amendable. Now, there are times when you die, you may want the trust to no longer be changeable. Like, for example, if you have children from a previous relationship, you want to make sure that your spouse doesn't change it after you die, your new spouse. You can set up a trust so it's locked down when you die, protect your children. And so, for example, maybe you want your new spouse to be able to get the income off of the farm, but eventually you want the farm to go to your kids. So while your spouse is alive, they get the rent, but then when your spouse dies, it all goes down to your children. So trust can be used in lots of different ways like that. The key is you must transfer ownership to the trust. This is where I see a lot of problems. People don't transfer the asset over. If you don't transfer the house and the other assets to the name of the trust is irrelevant. It has no meaning until it's called funding a trust. So it's very important that occur. While you're alive, you control the trust unless you get sick, and then somebody else will take over. Upon death, whoever you name as the alternative trustee will take over. If you become incompetent, they can also take over, and this is a much simpler process. You don't have to go to court. You can have a doctor, your normal doctor, just issue a letter saying that this person is no longer competent, and then whoever you name can now take over. So it's much less adversarial than having to go to court. It avoids probate. and allows planning for estate taxes. So down below here, I've talked about most of these already. I haven't talked about this, stepped up basis. Step up in basis. Okay, so first of all, this word basis. This is a tax law phrase. And essentially, this is how you determine when you buy something. So let's say I buy Amazon stock. What's it going for now? 2,000. It's way down. So it might even be below that. But look, let's just say I buy a share of Amazon stock for $2,000 today, and I own it until I die. So let's say when I die, it's now worth $10,000. So it's gone up in value $8,000. Now I haven't sold it. So I haven't, it's called realized that gain. The amount I paid is called my basis. So if I were to sell it at $10,000 and I bought it at $2,000, I would have to pay tax on that growth. So under current tax law, when I die, my children will inherit that stock at the fair market value at that time. So if it's worth $10,000 when I die, they then inherit it at that value. And all of that $8,000 gain, that if I would have sold it, goes away. That's called a step up in basis. This gets a little bit complicated, but this is a very important part of estate planning, because if you have highly appreciated assets like stock or real estate, you don't want to give it away while you're alive, because your children take over what you paid for it. When you die, they get a step up in basis, same as your spouse. They get a stepped up basis. And so that's one of the big advantages of inheriting assets versus gifting it. So a trust allows for that step up in basis when they inherit the asset. Now they're talking about changing that. We'll see. I kind of doubt it, because they have to rewrite. I mean, it would be so complicated to rewrite the tax code, but wouldn't be surprised. Question?
You answered it, but rewriting it, would that mean now the kids would be taxed on that
Correct.
appreciation value?
Correct, yeah. Now the problem, with this, again, real farming, maybe the parents inherited the property 80 years ago, and it was worth $100 an acre, and now maybe it's $10,000 or even $20,000 an acre of value. So if you got to pay tax and all that stepped up value, you got no money to pay the tax. You got to sell the farm.
Exactly.
Yeah.
So that'd just be like a house too.
A house, yeah.
So if
Any kind of asset, doesn't matter.
30-year-old gets their parents' house.
Right,
And now they have to pay the appreciation value.
right.
And they're most likely not going to be able to do it now. They can't.
They got to sell a house, yeah, or mortgage it.
Yeah.
So we've talked about most of these. One of the other advantages of a trust down here is if you do have out-of-state assets, you can have all of those assets owned by the one trust. So for example, let's say I have rental property in Ohio and Alabama and Arizona, and I live in Oregon. I will have all of those properties owned by my one trust. That way we don't have to go to court in every single state when I die. All right, so some of the disadvantages of a trust. First of all, the cost. It is expensive to set it up initially. It varies anywhere, but a typical non-estate below $1 million, you're probably looking at about $2,000, $2,500 to set up a trust. So it is expensive, but it's a lot cheaper than going through probate. Probate, probably minimum is going to be about $5,000 minimum, and it goes up from there. It's somewhat confusing. Probably somewhat's a little understated. It's pretty confusing. And plus there's this, I don't like my mother, but I've tried to talk to her about setting up, she just won't do it. Like, I don't understand it, I don't want to do it, and so there are other ways around that. But a lot of people just have this innate distrust of a trust, and that I understand that. You do have to retitle the assets, which can be a chore, because you have to do a new deed, you have to refill out all your brokerage forms and all of that. And it's not always needed, because there are these other ways to avoid probate that I've already talked about, that really, depending on if you have a lower value estate, you probably don't need a trust because you can do these other methods. And that essentially accomplishes the same thing. All right. So I've got here a list of kind of some issues that I've run into over my years. And some of these are duplicative. So, how to avoid or minimize post-death disputes. So first of all, as we've talked about, have up-to-date estate planning documents. And again, as part of that, make sure that you have updated names if there have been marriages or other changes in names, although we can fix that post-death, that's not hard to do. But also make sure you have all your beneficiary designations that coordinate with your will or trust or other estate planning, so they all fit together. If you do have specific items, personal things like family heirlooms, jewelry, sporting goods, things like that you want to go to specific individuals, it's a good idea to make a list. And then I like to have people take pictures, especially of jewelry, because if you just say you have the gold ring, well, what if there's 3 gold rings? You don't know. So take a picture and say this is supposed to go to this person, and then have alternative names if they die. After death, it's a good idea to provide all of the heirs with all of the documents and statements. Be transparent. Don't hide the ball. And what I mean by that is to avoid disputes. The biggest reason I see that people get into arguments post-death is they think that things are being hidden from them. And they may be right. But what I tell my client, and I do a lot of probate, and I advise people when they're doing probate and handling this, be transparent. Send everybody copies of the bank statements. Send everybody copies of all the brokerage statements. Send everybody copies of the deeds and the tax statements. Send everybody the register showing what bills you paid. That way everybody has the same information. And that way they can see what you're doing, and they can see that what you're doing, while they may not totally like it or they may not totally agree with your decisions on what bills to pay, at least they can see it's legitimate and they're working with all the knowledge that you have. If you hide stuff or you don't fully disclose, that's when we get into problems. That's when lawyers get involved. Debt owed by heirs. This is a real common problem that I see. So parent lends money to a child to maybe buy a house or a car, but they don't give that same amount of money to the other kids. Of course, there's going to be sibling squabbling, but how do you account for that? Well, typically, I will put a provision in a trust or a will that says, I've loaned X amount of dollars to my child. Upon my death, that's to be deducted from their share. Something like that. Okay, what if they can't agree? So I've seen some random ways to, maybe everybody wants, I don't know, the family quilt. Well, there's only one of them. So who's going to get it? Well, a couple different ways. Number one is you might flip coins, right? Or draw cards. So you take say you have 3 kids, an ace, a king, a queen, you shuffle them all up, put them in a hat, everybody draws a card, whoever gets the high card gets it. Another way to do that, and this is hard to do for family heirlooms that don't necessarily have monetary value, but you have a value put on everything, and then you essentially buy it from the estate. You don't actually pay for it, but it goes in your column, and you're charged that amount of money, and everybody else gets an equalizing amount of money to make up. Do a spreadsheet. All right, a no contest, lose it all clause. This is a provision in a will or a trust that basically says if anybody contests the validity of the trust or the will or the manner of distribution, they lose their inheritance as if they died. And then it goes to whoever is the successor. That shuts down a lot of disputes right there. The phrase absolute discretion of the trustee or personal representative. This is a phrase that basically says the trustee or personal representative has absolute final discretion. They don't need to get input from anybody. They can make the decision absolutely, and that will usually be respected by a judge. Make sure that somewhere you have your passwords and digital rights, login information and list of things, so that I myself have a little ledger that I keep, and I keep it right. I have a trust binder where I put all my stuff. I have all my passwords in there. I have crypto, so I have my seed words. If you don't know what that is, if you have a crypto account, you have 12 words, which are generated one time and one time only, and you better write them down, because if you ever have to recover your account, and if you don't have those 12 words, that money's gone forever. There's a guy, I was reading the paper the other day, he has like 200 million in Bitcoin. You can't remember his seed words. So, yeah, he bought it when it was like 10 cents a Bitcoin. Now think about those seed words, just saying, if you do crypto, don't give those seed words to anybody. If a broker or any crypto company ever asks you for them, the only time you should ever give them is directly to the crypto company that's holding your coins, and that would be in a form of they would ask you for your seed words and you put it in. You got to be very careful about giving those seed words out, because that could be hacked, and you may lose. If you've got significant money in crypto, you lose all that. It could be hacked. There's really no way to recover it. So same thing with passwords to other types of accounts, but especially with crypto. And also, if there's a will contest, a will can be contested. If it can be shown the person was incompetent when they signed the will, or if they were under undue influence, or the will was done improperly, that leads to litigation in the probate court, and that's really expensive. It's very hard to overturn a will unless there's really obvious evidence. Okay, this is duplicate. How come? Okay, here we go. All right, some other issues. Medical record release. It's a good idea to have your healthcare providers, you should add names of people onto your account directly using their forms. They're going to have their own forms for that, to authorize maybe a child or obviously a spouse, but a child or a couple of them to be able to access your records if you get sick. That way the doctors know who to talk to. That can be part of that living will advance directive, or it could be a separate document. Most healthcare companies, Kaiser Permanente, Salem Health, they have their own form. They won't accept anybody else's form. So that's a form you have to do directly with your healthcare provider. Digital right passwords and keywords, I talked about that already. All right, green box and post-death instructions. A green box is a phrase that's sometimes used that describes basically a letter or a box that contains all this information, which includes maybe some family history about certain items, a list of what assets you have so people know what you have. A lot of times people have no idea, even your spouse may not know all the assets, the kids may not know. So just instructions on where things are, what accounts you have, what accounts you may have that really don't have any value, just so people know. I talked about those. Oh, proxy voting. Talked about proxies a couple classes back, but this is where you transfer your right to vote corporate stock or an LLC. And so if you become incapacitated, especially in a family business, it's a good idea to have somebody with that authority. Now it's usually contained in a power of attorney form, but not always. And it also may be subject to the family business shareholder agreement that limits who can have proxy voting rights outside of the family. So you gotta make sure those all work together. Good idea, especially in a family business situation or other small business, to have life insurance that might even be purchased by the business itself. That could be used to fund a buyout of the deceased person's family. That way you don't end up in business with other people that are not part of your family, or the children of your deceased partner, that kind of thing. Talked about crypto and, real estate, okay. A shared use agreement. This is a shared use agreement is when you have multiple owners of real estate. And where I see this commonly is something like a beach house or a vacation house. That's a family-like cabin. So parents bought it, maybe Sun River, and then the kids inherited, say there's 4 kids, they all have a 1/4 share of the Sun River house. Cool, or the beach house, or whatever. Now they gotta figure out how you're gonna use it, because they're all gonna want Christmas, or whatever. They're all gonna want Memorial Day weekend. What if they want to rent it? Are they gonna give discounts to friends and family? Are you gonna rent it full bore? Are you gonna allow people to use it for free? Can the friends of the friends use it? Can the friends of the kids? I mean, it gets messy really quick. So it's a good idea to put together a shared use agreement, like a rotating calendar where the holidays are rotated it's almost like child custody. You rotate the holidays, so if you have 4 family members, every 4th year, they get, maybe the winter holiday season and whatever. I think I'll save these last 2 slides, so. The bottom one I'll talk about, just real quick. Another thing I tell people, especially in small business or family-run business, make videos on how you do things that only you know, like how to log on to your crypto account. Make a video. Be careful what you post it. But, like me, I live on a well, and I have this elaborate water conditioning system because my well water is not all the best. My kids and my wife have no clue what all those little things do. So I've made a video, so if I'm gone, they know, okay, here's how you turn on the pump, here's the breaker to shut it off, here's what it looks like when it's running properly. And I actually I got a private channel and I posted it there, so if I'm gone on vacation and the well goes out and my daughter's home, like, Dad, what do? Well, watch the video. Here's the YouTube link. So, depends on what it is, but it's a real good way to, look out for those kind of problems. Make a master list of the people that are involved in the business. Let's say you start a business, you're going to eventually turn it over to your kids. You're the one who knows all these people. Frank from Indianapolis, who's been providing you with parts for your machines for 25 years. Well, I know who Frank from Indianapolis is, but my kids don't. They don't know, who's Frank. So make a list of the important people that you do business with and what their role is, and perhaps what the next generation for them as well. Have a family charter, perhaps, and this is where you lay out, if you want to take over the business at some point, you have to go maybe work for other companies first, so you get outside experience. Do you need to get a degree or some other certificates of educational qualification? That way you avoid a problem where family members are perceived to be given favors over non-family member employees or whatever. So those are all kind of issues. I'm about done with this topic for today, so I'm going to go ahead and cut it off there.